All rise. All persons have the business before the Honorable Associate Judges. Now back to the District on your Court of Appeals, draw near and give your attention. God save this United States and this honorable court. This honorable court is now in session. Please be seated and come forward.
Good morning, everybody, and welcome to the DC Court of Appeals. We have 3 cases on this morning's regular calendar, and the first one up is Sim Development versus District of Columbia et al. 21 CV 597. Okay. Can everybody hear? And who is going to start for Sim?
Good morning, Your Honor. My name is Kenneth Crickman. I represent Sim Development LLC.
Right. Thank you. Please proceed.
Thank you. May it please the court. I know the court has read the briefs and is familiar with the case. So unless there are any initial questions, I would like to begin by focusing on 2 material and undisputed facts in this case. As it pertains to the tax sale foreclosure. The first fact is that the taxes, the real estate taxes, were paid by my client in April of 2016. And while my client contests that they were actually paid 2 months earlier in February 2016, the District of Columbia acknowledges that they were received on April 2016. So for purposes of this argument, I'd like to use that fact. Which hasn't been disputed. The second fact is the payment of the legal expenses of the tax sale foreclosure purchaser. And while those were paid actually in a real refinance closing in February of 2017, there was a $50 or $60 amount still owed that the settlement company, which is Appellee MBO Settlements, paid in June of 2017. So for purposes of these arguments, I'll accept that the legal expenses of my client for purposes of redeeming the foreclosure sale were paid in June of 2017. So those 2 facts are relevant under the DC Code section 47-1361 D. Under D1, after receipt of the payment of taxes, the mayor shall notify the purchaser of the payment. And we know that that didn't happen, or at least 2111 counties didn't acknowledge that information because it was later asking the district whether the taxes had been paid. But the district under the statute had a statutory duty or obligation to notify 2111 counties in April 2016, and apparently that didn't happen. Under D2, under the same code section, once the tax sale purchaser may continue to prosecute the complaint to foreclose the right of redemption until receipt of the expenses owed to the purchaser and payable to the purchaser by the redeeming party. That occurred, as we know, in June of 2017, and yet 2011 counties did not dismiss the complaint, and it actually continued to prosecute it. And so that led to some confusion, obviously, between the district and 2011 counties as to what was paid and what wasn't paid.
Well, that's one. Oh, sorry. That's one question that I have is as to your claims against the district. The whole debate over what the email meant and how it was interpreted and all of that. Why does any of that matter if the real problem was after the complaint for foreclosure was filed and before counties filed its motion for judgment in that case, they knew that redemption had occurred?
I agree that I think counties was the primary party responsible for this occurring. And they did acknowledge at 2 hearings later in May 2017 and in September 2017 that both the taxes and the legal expenses had been paid right before the court. And then 2 months later, in November 2017, the court issued the judgment, not knowing any better, obviously. And based on that judgment, the tax deed was issued. So I understand the question, Your Honor, and I understand that the 2011 counties was primarily responsible. However,
I guess I want to push you on the primarily is how did the district's actions, even if everything you say about them is true, what harm did they cause?
well, I think there's two points to that. One is that they didn't notify the purchaser pursuant to the statute 47-1361 at the time of the payment, which they acknowledge and they admit occurred in April 2016. So
Can I ask you a question about that just to make sure? The notice provision that you're relying upon, you read it, do you read it as saying that the district was required to give notice each time any one of the payments that is listed in, is referred to in D1 is made? Or do you instead think it should be read as meaning once everything is done, then the district has an obligation of giving notice? Because if it's the latter, then the timing would be different about when the notice is required. So how do you read it? Do you understand the question I'm asking?
Yes, Your Honor. I read it as the district would be required to convey the information that it had, which would have been receipt of the taxes. It wouldn't have known whether the tax sale purchaser had received its legal expenses, unless obviously there was communication between those parties. But I read it as the A1 through 6 payments that were required were inclusive, but really the district would only have known about the taxes being paid at that point.
In the complaint, you just remind me, was the theory that the district's negligent omission was the failure to give notice pursuant to this provision? Was that the part of the theory of the district's negligence? Because my recollection of the focus of it was at least the focus of it. I'm wondering whether it was more than just the focus of it, but instead it was kind of the exclusive basis. Was the district's response, into the email exchange that
Yes.
Has been focused on?
Yes, that's correct. And as you have pointed out, there may be some discrepancy under the statute as to when the statutory notice kicked in. If it included taxes and legal expenses, then perhaps the district wasn't obligated. I interpret it differently, but I think there's a clear obligation when the district was asked in the email exchange in January of 2017 by the tax sale purchaser directly, were the taxes paid? Are we entitled to continue our foreclosure? Please check the records, et cetera, et cetera. There's a lot of emails back and forth. And ultimately the district said, we don't consider the property having been redeemed. And again, which
you agree is factually accurate. If I understand your argument is yes, that's true, but some things that are true are misleading, and maybe they could be misleading enough and unreasonable enough in context that they could give rise to liability. But you don't deny that was the literal words there taken out of context and just considered as a proposition were accurate when stated.
I agree, and I think that's a matter of interpretation, and it's a material fact that's in dispute, because I think the district, why would the tax sale purchaser be being asked? Why was it asking the district whether its own legal expenses were paid? It would have known that. It was clearly asking whether the taxes were paid, which only the district would have known. So I understand that there's ambiguity in the district's response, and that technically, yes, it wasn't redeemed, but the question was about the taxes. And I think,
I guess that's what the question is, whether that's a reasonable way of looking at it, sufficiently reasonable to get to a jury. That would be the issue with respect to this aspect of the case. And it seems as though, to me, if you look at the email exchange, there's like a chain of emails, and the person who responded, the Assistant Attorney General ultimately responded, Mr. Wood, I think, was not a communicator on the original exchange, but as far as you can tell, they were all available to him depending on how far back he was reading in the exchange. I guess it seemed to me somewhat unclear. You're saying, well, the district ought to have understood that given what it would not normally know and what counties would have known. It should have kind of zeroed in on what was the operational aspect of the question and its answer, which was general in terms. It should have realized that its answer might have been misconstrued by the person who was hearing it as, a more specific assertion that was factually inaccurate. That seems pretty tough in light of what seemed like a pretty murky set of email exchanges before about where different people were framing different questions and reframing them in various ways. So if you were can you situate your argument in is there any reference at any point where someone is saying, what we're really trying to get at here is whether the taxes have been paid? Or does your theory rest entirely on the idea that the district should have thought, well, who's asking? What's the practical reason why they might be asking? What do we know? What do they know? Probably if they're not sure, it's because there's a part of the inquiry that we know that they don't know. And if I give a general answer, they might misconstrue it and think that it's really about what I know and not what they would know. I mean, that all seems, that seems pretty, Monday morning quarterback hindsight-ish, I guess.
Yeah, I understand the point, Your Honor. And I'm taking that also in context of the statutory duty that I mentioned earlier, but also after following those emails, there were at least two hearings where the docket reflects that the court was notified. The district was present, it wasn't, and the tax sale purchaser, and both acknowledged before the court that both the taxes and the legal expenses had been paid. And the last hearing was 2 months before the judgment. So I'm not blaming.
Does that help you or hurt you? I mean, if the district, depending on whether Mr. Wood knew that, if Mr. Wood knew that the district otherwise had said in open court that the taxes had been paid, then Mr. Wood, I would think it'd be all the less reasonable for Mr. Wood to be thinking, oh, well, it's possible the county will misconstrue what I say and think that it's contrary to what we said in open court.
Well, I think Mr. Wood later, after doing his proper research, discovered that the taxes had been paid actually in April of 2016, and that was never brought to the court's attention. I think both parties had a duty and an obligation to present truthful and complete information before the court would issue its judgment, relying on the information that it was receiving from the parties that were present at the hearings. And
if we assume that there was some negligence on the part of the district, how do you get over or get around the public duty doctrine in this circumstance? It would seem that if there were a special relationship, it would be between the tax sale purchaser and the district, who, after all, was the one who inquired about whether there had been a redemption. And even the statutory provision that you mentioned calls for a notice to the purchaser, not to the property owner. So what's your response to that?
Well, yeah, I think that, well, taking the second question, the tax sale the notice provision under the statute was to the purchaser, and that's why the purchaser should have known that the taxes or would have known that the taxes had been paid had that statutory provision.
Right, but where was the duty to your client? Where was the special relationship with your client?
I see it as a special relationship with the property owner, the property itself. At that time, 2011 Counties was representing itself as the owner of the property by virtue of the tax sale, while my client was the owner of the property for title purposes until the tax deed was recorded. So the communication was between the district and a specific property owner, which was really, could have been, was technically my client all along, because that tax deed was later overruled and voided. But at the time, the point of time that there was communication between the district and the property owner, that party was 2011 Counties. But I think that created a special relationship with this particular property. The district was communicating information, not just generally to the public, but to a specific property owner of a specific property. And there's also the point that my client was involved with the district all along with respect to his renovation plans. So he was in contact with the district as well, not just 2011 Counties. So there was a special relationship in that regard as well. And he ultimately heard about the fact that he had lost title of the property from the district directly. So that shows that there was communication between my client and the district, as well as between 2011 counties in the district. So I think all of those facts, show a special relationship beyond just the duty of the district to send out tax bills to the owner, the general duty that the district would normally have with every property owner.
Mr. Crickman, you're running out of time. Do you want to touch on any of your other issues? We will give you time for rebuttal.
I think that's it, Your Honor. Thank you. I will conclude.
Okay, do my colleagues have any other questions? Okay, thank you. And for the appellees, have you all discussed how you will be breaking up time?
Yes, Your Honor. May it please the court, William Day on behalf of Appellee MBO Settlements. The order of argument is going to be MBO Settlements first, 2011 counties second, who is remote, and the District of Columbia third.
Okay, great, thank you.
Your Honor, the two counts on appeal regarding MBO settlements are account of negligence and account of breach of fiduciary duty. Both claims have the essential element of a duty of care. And as you're aware from the briefs and the arguments, SIM Development did not offer a standard of care expert or proffer any expert in this case at all to prove what the standard of care was for a settlement agent and how MBO deviated from that standard of care.
Can I ask you, do you dispute that your client's status as a settlement agent gave rise to a fiduciary duty?
Excuse me, Your Honor?
Do you dispute that your client's status as a settlement agent gave rise to a fiduciary duty that your client had to SIM Development?
I don't dispute that there was a duty. The argument is that he has to show.
I understand.
Okay,
Yeah, I was just, going step by step.
So that there's a duty.
Why do you think an expert, if the allegation, I understand the complications posed by the efforts to record the deed and the obstacles that were confronted. But leaving that aside for a minute and focusing on what I take to be, I think, two other claims of breach of fiduciary duty and maybe also related negligence claim. I think related claims of negligence. One was taking money to secure a title insurance policy and then not doing it. And then the other was taking money to pay, I think, some taxes and not doing it. Why do you need an expert if, assuming those weren't done, and assuming that there isn't any complicated story about why they weren't done, that you might need an expert to assess how reasonable it was? Well, why do you need an expert? Why wouldn't common sense tell you that if you have a fiduciary obligation to someone and you take their money and to do something and then you don't do it, that's a breach of fiduciary duty? Why couldn't a jury find that without the aid of an expert?
Because the complication arises in the inability to record the deed of trust because of the change in tax classification. She couldn't issue the title policy until the deed of trust was recorded, and that's in the record, according to my client's.
And how about the payment of taxes?
Again, it's since there was a change in tax classifications. SIM Development said that they were taking on the responsibility of remedying the tax classification issue. So until that was remedied, the amount of taxes that were owed were not due because the taxes are paid and the fee paid when the deed of trust is recorded. And so the problem is that
so is it a fair summary of your response that really all of these acts get tied up into the question of whether your client acted reasonably when confronted with the obstacles that seem to be not necessarily factually disputed, that your client, tried to record the deed, ran into obstacles, notified SIM of them, and whether that was a breach of fiduciary duty or whether that was negligent would require, a layperson can't answer that question. You would need an expert. Is that, and your point is that carries through to all of the acts and omissions that were the predicate for the breach of fiduciary duty and negligence claims. Is that?
That's exactly our argument, Your Honor, because or at least I can, and I've done some real estate transactions, can't look at a settlement sheet, a HUD-1, and say, okay, you need to record this deed of trust. The tax classification has changed. What's my duty then? I contact SIM development and say, hey, the tax classification's changed. I couldn't record the deed of trust. What's her duty then? After that, does she have a duty? And only a standard of care expert can say what that duty is. What does she have to do when you run into that situation? You, as a standard and a lay juror, can't look at the settlement sheet and say what her duty is. Why wasn't she able to record it in the first place? Because of the change in tax classification. How does that affect recordation of deeds of trust? Why she couldn't record it? How changing the tax classification? What she should have done at that point, if anything? Did she do enough by contacting SIM development? These are all questions that a standard of care expert is required to do. A layperson can't answer those.
And just to be clear, when you were speaking a minute ago, you said that the connection between the difficulty in recording the deed and the failure to get a title insurance policy and failure to pay the taxes is, quote, in the record. Can you be more specific about what you mean about who identified in what place that connection?
I don't know the exact appendix number, but I know that my client testified that in her deposition. But those are all intertwined, and as you can see from the record, that's when everything stalled out, is when she was unable to record it. Her first time contacted SIM development, tried to record it a second time, still unable to, tried it multiple other times, still unable to. And SIM development admitted in his deposition that he took on the responsibility of remedying the tax classification of the property, not MBO. And so her duty as the settlement agent was to continue and to close out that transaction, but she was unable to because of a tax classification change. And so what was her duty? That's not a normal situation in a settlement. What is her duty when you run into that problem? What should she have done or not have done? And so that's, I think, where we need a standard of care expert to say what happens in those situations, and that wasn't done.
Does the record disclose what the order of magnitude difference was between one tax classification and the next? I can't recall. I mean, here's what I'm thinking. I'm thinking if, the difference was $5, why not record it and pay the $5? Get a refund?
I don't think it was that, Your Honor. My understanding, I think the record will show that it was between class 1 and then blighted, which, as you may know, astronomically raises the taxes to the tens of thousands of dollars. And that's where, and he was developing the property. That's not in dispute. And so at some point, the district designated this property as blighted, which changed the tax classification severely. I think if it was a matter of $5 or so, it would have.
Well, that was kind of a ridiculous example, but that was the reason for my question, because it does seem to me if the amount were small, one might say, well, a jury could certainly conclude without an expert that the thing to do would have been to just go ahead and record it, pay the extra, get the money back. And if we're talking tens of thousands of dollars.
I don't think the record explicitly says the amount, but I do know that the record does show that SIM development was actively appealing the tax classification, which took some time. And so I don't think that would have happened if it was a nominal amount. But I don't think there was an exact dollar amount. Any other questions? Sure.
Thank you very much. And you said 2011 counties next. So Mr. Callahan. You are on mute.
I apologize. Good
No
morning,
problem.
Your Honors. John Callahan, may it please the court. I represent Happily 2011 Counties LLC. This appeal concerns 2011 counties, does not involve negligence. It only involves fraud and negligent misrepresentation. And as the trial court correctly concluded, SIM's fraud and negligent misrepresentation claims against 2011 counties didn't satisfy the basic requirements for causes of action for those two torts. I think if this appeal involve whether or not Sim was negligent in some way, shape, or form, I think this appeal would be different. But there's
Can I
nothing.
ask you about that? Just out of curiosity, is there anything in the record that explains, where 2011 counties is giving an explanation for its decision to go forward seeking the judgment when it knew everything was paid? I understand your appeal is pretty formalistic, but is there anything in the record on that?
Surprisingly, there's nothing in the record. There's no deposition or anything like that where anyone asked 2011 counties, why is it that you continued this case? I have a pretty good idea as to why, but it was never addressed in the record.
Thank you.
Did
I
you
have-
want to tell us what your pretty good idea is? We won't hold them to it.
Well, if you read the controversial email exchange in January of 2017, I mean, obviously, well, let me step back. As you know, in order to redeem a property from tax sale, the property owner needs to do two things. One, pay directly to DC everything that it's owed for taxes, and then pay directly to the tax sale purchaser its legal fees. Once those two things occur, the property is redeemed from tax sale.
I thought there was a third thing, which is pre-complaint expenses, which I guess ultimately go to the purchaser, but maybe I'm a little confused on this, might be paid to the district, but I thought there was a third category. I thought there was, taxes, then there were pre-complaint expenses, and then there were post-complaint expenses. Am I?
It's very
misrecollecting?
confusing unless you do this for a living, Your Honor. The pre-complaint taxes are paid directly to the city, and then the city reimburses the tax sale.
That's what I thought. I just thought there were three categories that I thought you were sort of saying taxes and, complaint. And I thought there was a third category that was confusing because it is paid to the district, but ultimately then gets channeled through if things are working properly.
Exactly.
To the tax purchaser.
Correct. In any event, the January 2017 email that Mr. Wood sent, I mean, obviously 2011 counties wouldn't be asking Mr. Wood if its own legal fees were paid. It would know that from its own accounting. Another issue, I don't
Well,
think.
I mean, you say that's obvious, but, people are in organizations and, I think people sometimes don't know things that other people in their organization might know. So I have no idea whether the person who's asking that question would have all the knowledge that it would be available, or was just taking a shortcut. And it's like, well, I'm talking to the district. What does the district think? Is it redeemed or not? So I'm not sure it's quite as obvious as all that the district would know, or would reasonably believe that whoever is asking the question would know whatever you might think a person who had taken the steps to be knowledgeable could have found out.
Understood. The other issue, Your Honor, under DC Code 47-1361 D1, when the real property taxes and pre-complaint legal expenses are paid in full to the district is supposed to refund the tax sale purchaser for the monies that the tax sale purchaser paid in connection with the tax sale, irrespective of whether the legal fees have been paid. So I think that if the district had refunded to 2011 counties the monies it paid for the tax lien certificate, it would have been clearly on notice that the district considered the taxes paid in full.
I ask you, there's something in the record that is a spreadsheet that the district made available to 2011 counties that lists a whole bunch of properties, because apparently they were inquiring about a whole bunch of properties at that point. And if I'm recalling correctly, that spreadsheet with respect to the property at issue I forget the exact words, but it doesn't say taxes are owed. It says something about, certification or release and something needed. And I was just wondering what significance you attribute to that, although I apologize for misrecollecting the exact wording of the entry.
I actually know what you're referring to. You're referring to a July 19th, 2016 email that Mr. Wood regularly sends on Tuesdays to the parties involved with the tax sale calendar, which always takes place on Wednesday, and gives them sort of a status of what the district views as the redemption status of the properties. I shouldn't say redemption because we all know that's confusing.
Right. I mean, I found in Appendix 371 what is represented that the status report said, and I think it's that status report is also in the record in the appendix somewhere else, but it says need, release, or assignment.
And that's a tax sale jargon for the taxes have been paid in full. However, the district seems to have changed its mind later down the road that actually the taxes weren't paid. Sometimes the district gets it wrong, that the taxes have been zeroed out.
And when you say the district later changed its mind, I mean, obviously the email exchange, the ultimate email answer is, I think everyone would agree, at least not explicit as an assertion that there were taxes owable. But there was a later point at which the district, in your view, unambiguously said, yes, definitely, taxes have not yet been paid.
I don't think, based on the conversation or the discussion this morning, it's unambiguous, but the January 24, 2017 email from Mr. Wood would be viewed by 2011 counties as the district saying that the taxes have not been paid in full, simply because 2011 counties wouldn't be asking whether our legal fees have been paid.
Was it when you say that the district apparently changed its mind from what had it appears that the district had previously told 2011 county, which is the taxes have been paid, if that's what you would say, the parties to those emails would understand those words meant, though they're not explicit, I gather. And when you say that the district apparently changed its mind, just to clarify, are you relying for that assertion only on the answer by Mr. Wood at the end of that email exchange, or is there something else that you are referring to that happened in between the statement that we're referring to here and the email answer by Mr. Wood?
I think that if Mr. Wood in his January 2017 email had said that the taxes are unambiguously paid in full, I think if Mr. Wood had said that, we wouldn't be here today.
Well, just to repeat my exact question, I understand your position about how to interpret Mr. Wood's email in January. But my question was, between the statement that was made in that spreadsheet, between the date of that and the time of Mr. Wood's email, was there anything else that you think the district did that suggested that the district had a different view than what was reflected in that spreadsheet?
The record doesn't reflect anything like that, Your Honor. I would add that as of July 2016, the legal fees hadn't been paid. So under any scenario, 2011 counties was well within its rights to continue its tax sale foreclosure.
Understood. I think that's undisputed.
Agreed.
Thank you, Mr. Callahan.
Thank
If
you.
Don't have anything further, we will hear from the district. Mr. Love.
Good morning, and may it please the court, Richard Love for the District of Columbia. Let me start by saying that with regard to the notice requirement in 47-13-61 D1. There's also a provision in D4 which says notice may be made by making the information publicly available. If you look in the record at page 442, there's a declaration from Mr. Coyne, Thomas Coyne, who says that the Office of Tax and Revenue has a publicly available database that shows taxes that are outstanding and taxes that are paid, and that that database showed that the April 26 tax payment had been made. So the district satisfies its notice obligations. But more importantly,
Can I ask you, is another possible way in which the district satisfied that obligation the status report
sure.
that we were just discussing with preceding counsel that is referred to on page 371 of the appendix, which do you agree that the words need, release, or assignment communicates that taxes have been paid?
Yes, I think that's explained in the filing that the district made in response to Sim's motion to vacate the judgment. That's at 370. And specifically at page 371, it's Mr. Wood's filing. He explains what that means. There's also a notation on the tax sale docket that it's on July 20th, 2016, the next day, that says the taxes were paid.
But you also, I think it's that pleading, the response to the motion to vacate the judgment, is that right? Where the district also admitted that counties, 2011 counties, believed at that point that that Mr. Sim still owed taxes, or not Mr. Sim, sorry, Sim still owed taxes.
Yeah, I can't remember the exact sentence. I know, but I think that is not supported by the record. If you look at, in fact, regardless of how you interpret the AAG Woods January 2017 email, if you look at the tax foreclosure docket, it says on May 17th, 2017, and it's plaintiff, and the plaintiff here is counties. It's their foreclosure action. They indicate that Sims paid its taxes, and that's at the appendix at page 268. That's at the status hearing on May 17th, 2017. They said they needed to verify, but the taxes were paid, but needs to verify is I believe the exact quote. Then at the next status hearing, which is on September 13th, 2017, again, Ms. Byers, whose county's attorney, represents to the court that the legal expenses were paid in June. So there's no way that Sims's theory that but for Wood's January 27 email, counties wouldn't have continued its foreclosure action when it indicated itself, its attorney represented to the court that the legal fees had been paid on May 17, 2017, and represented that the legal expenses were paid in the September 13th status hearing. Nonetheless, it went on for 14 months until a judgment was entered foreclosing the right of redemption on the property. So any causation issue, ends, I would submit, when the post-complaint legal expenses were paid to counties directly in June of 2017. But at worst,
am I right in recalling that this causation point you're raising was not the basis for the trial court's grant of summary judgment?
it was not, Your Honor, but
I understand it's available to us as an alternative ground, but I just want to clarify whether.
And I would point out that this is in Sims's own brief. I mean, I think he mentioned it in arguments that there were 2 subsequent hearings. He's incorrect that the district was present, and I'd like to get to that point in a minute. But if you look at their brief, they raise these 2 directly contradictory arguments that the district's January 2017 email is responsible for this foreclosure action continuing into November 2018. But nonetheless, they point out that the record shows that counties itself made these representations on both May 2017 and September 2017. If I could, then leads me to the issue of the docket and the district's role in these tax cases. I'd like to put that in context, if I could, for just a second, because at this time, the tax calendar ran every week, I think has been alluded to, I believe at that time on Wednesdays. And it was a very large calendar. There were 50 cases on the tax calendar at this time about, and the district was a statutory defendant in every single one of them. There's no way the district could know everything that's going on in every one of those 50 cases. It's a nominal defendant, and it's not the plaintiff. It's counties who initiates the foreclosure action. It's counties who is responsible for prosecuting it. And if you look at the docket, it doesn't say that the district was present at either of those two hearings. It says, this matter was continued and continued and continued for counties to effectuate service on SIMs. And there were various problems with service. But you'll see that the plaintiff is present every time. The first time there's an entry where the district is actively participating is after the March 2019 motion that SIM filed to vacate the judgment. If I could just say.
But wait, and your point there is what?
I just wanted to make clear that the district wasn't at either of these hearings that I believe Sims's counsel referenced that the district was present at those hearings. It was not. I mean, it's not referenced in the docket. But moreover, the district, had no obligation beyond what it properly did in this case to somehow have rectified county's mistake in continuing its foreclosure action beyond payment to it of its legal expenses. I had one more point I wanted to make before I sit down, unless the court has other questions, and that's with regard to Your Honor's question on the special duty. There was a response that basically there was contact between the district and counties. I don't think that satisfies the requirement for a direct and continuing relationship. And the only direct relationship that SIM has identified is a March, I believe, 2019 meeting in which, with regard to his tax classification issue, in which he found out that he was no longer the title owner of record to this property. Well, one, I don't think that satisfies a special relationship. Doesn't, it may be a direct contact, but no matter how you slice it, he couldn't have relied on that meeting to his detriment, because 8 days later, he filed a motion to vacate the judgment, which the district subsequently did not oppose, and the judgment was vacated and the property, title to the property was returned to SIM. So unless the court has any other questions, I would submit that, the district, it can't be a negligence for a literally correct statement and for complying with the court's judgment order in this case. And we would ask that you affirm the Superior Court's judgment.
Thank you, Mr. Love. Mr. Crickman, we will give you a few minutes for rebuttal.
Thank you. With respect to the MBO arguments, with respect to the payments that weren't made, I don't understand why whatever taxes were collected weren't paid to the district. Even if it wasn't the entire amount, they held the money and held it for a long time. I think they're actually still holding it. The recording, it seems like the defense is that, well, we couldn't record the deed of trust because there was a change in tax classification. I've never heard of that before. I don't understand. I've recorded many documents. I'm not testifying here, obviously, but that's not something that the recorder of deeds would check. That's something that if you pay the recording fee and you pay the transfer taxes and recordation taxes, that the trust goes on record. In any event, there is a, rather than have an expert, if that's a matter for an expert, that would be a matter of the statutory terms. And we did identify a representative of the recorder of deeds as a potential witness who could have testified on that point directly.
Can I ask you, do you, with respect to the failure to obtain a title insurance policy or issue one, your opponent suggests that that was kind of intimately intertwined with the difficulties in recording the tax deed itself. And I know you take the view that, as you were just saying, that you think that a jury could find adversely to your opponent about the failure to record the tax deed. But do you dispute the kind of subsidiary point that your opponent is making, which is those two things kind of stand and fall together because it was explained in the trial court, and the trial court, I guess, could perhaps accept this explanation as undisputed, that the difficulty in recording the deed, assume for a moment it wasn't itself a breach of duty, would be the explanation for the failure to obtain a title insurance policy?
Well, the title insurance policy should reference the recording of the deed of trust when it's delivered to the lender. That's standard. I'm sure every title insurer would expect that of their agents to issue a policy. So I don't disagree with that point. But the larger point is that the lender, Capital Bank, who was expecting that title insurance policy and recorded deed of trust, didn't even know they didn't have it. And I personally had contact with the Capital Bank representative. I informed him about 2 years after that settlement, you guys don't have an insured security interest in this property. Immediately, and this is all a matter of in the record, immediately the representative of Capital Bank responded after consulting with his attorney. Within several days, he called the loan in full and basically said, we're not, this is not a secured loan. This we're calling the loan this the payments for the construction were canceled, and my client was forced to repay the loan in full at that point. So that goes to what shouldn't have NBO have notified the lender that they didn't even have a secured and insured interest in this property. And that's another point to their negligence, why they should have just, if they could have recorded the deed of trust, record it, issue the policy, and let my client deal with the tax classification issue. If my client owed more money to the district because of the.
Can I ask you, to the extent you're just suggesting, sorry, there was a lag, I apologize. To the extent you're suggesting now that a different omission of negligence was that at a minimum, MBO, when it ran into these obstacles, in addition to dealing with your client about the tax classification issue, MBO ought to have notified the party involved in the loan about there is no title insurance policy, your loan is not secured. Is that alleged in the complaint as like a separate act of or omission of negligence, first of all?
I'm sure it was. I don't have the specific reference here. It is a matter of fiduciary duty. That's
well, and then just if that were negligent, I'm a little unsure about how the causation would work, because if they had done that, I assume everything would have fallen through just sooner rather than later. So I'm a little unsure exactly what the causation theory would be. But again, I just wasn't sure that had been kind of separately presented as a basis for a negligence determination. And I wasn't sure the trial court had kind of zeroed in on it either. So I'll have to go back and look at the complaint.
That's right. It wasn't zeroed in at the trial level. It certainly was alleged in the complaint as as one of the points under either negligence or breach of fiduciary duty, which gives rise to a duty to inform. If there is a fiduciary duty, and I think everyone agrees that there was, that MBO had a duty to inform SIM and Sim's lender.
Well, Sim, I thought Sim was informed about at least the failure to the obstacle that MBO perceived in trying to record the deed. And I thought you said just a minute ago that it would have been obvious that that would have also precluded issuance of a, if MBO is telling Sim, look, we can't record the deed, then Sim would have understood that, well, that means there's no title insurance policy. So I'm not quite sure about the notice piece of it that, to Sim that you're focused on now.
Well, that's another disputed fact. My client wasn't aware of that. I know MBO has since claimed that they kept him informed, but he didn't know. He didn't, and it is in his affidavit, which is part of the record, that he wasn't aware of it until much later. He was focused on his construction and so forth, not the title insurance issues. And he assumed that Capital Bank had been satisfied in that regard. So
Do you think a jury would have been able to determine without an expert that the settlement agent had was remiss in not notifying Capital Bank? I mean, I suspect a jury might have thought what Judge McLeese just said, which is that telling the bank might have just caused the whole loan to fall through earlier in time. They'd have called the loan on day one instead of day whatever it was, day 700. I'm not sure what the settlement agent should have done in that circumstance, and I wonder whether a jury could have known without an expert. So what do you say to that?
Well, I say that fiduciary duty brings with it a duty to keep the party that you owe the duty to informed of all facts that might affect its interest and its property interest and its ownership interest in the property. And so that would have been, whether it happened later or earlier, that duty arose as soon as the deed of trust wasn't recorded and the title insurance policy wasn't issued, to keep everybody informed, and that, certainly Capital Bank has admitted that it wasn't informed. My client says he wasn't informed. There seems to be a dispute about that fact, but I don't think that's a matter for an expert to testify on. I think this is, especially with respect to the settlement statement charges, it's like analogous to a mail carrier. You're given a stack of letters that have addresses on them. You simply get the letters to those people. If you take those letters and take them home with you and put them in a drawer, I think any lay person could say, well, that's negligence. That's not fulfilling your duty of care with respect to delivering those letters. And the settlement statement says,
I mean, the difficulty with that analogy is it seems that this case is not so much that, because it seems to be undisputed that MBO made at least some effort to deliver the letter in your analogy, and instead of, so knocking on the door and someone won't receive the letter, and maybe they should be receiving it, maybe they shouldn't be receiving it, and what's what's a letter carrier to do in that setting, then you might think that lay people wouldn't have a necessarily good answer to that and might need assistance from somebody else who knew more about what letter carriers are supposed to do, and when they're running up against obstacles that seem to be technical in character.
yes.
Can I,
Yes.
go ahead if you want to respond further.
I think I had already responded to that before the question, but so.
Okay, can I ask you to clarify something that you said when you were when Judge McLeese was asking you about the kind of relationship between the failure to register the deed issue and not getting title insurance and so forth. I think you were saying they should have at least gotten the title insurance and let Sim deal with the classification issues. Is that inconsistent with what you said when you agreed that they were intermingled? And I'm sorry, I don't know how this actually works, but I think you said the title insurance would note the deed of trust. So does that mean the registration has to happen before the title insurance, or it's just better if it does?
Just to clarify, I was saying that the deed of trust is intermingled with the title insurance policy, but the tax classification issue is a separate issue. And I don't think recording the deed of trust is reliant upon resolving any issues with the tax classification. That's between the taxpayer and the and the district. And
But isn't that the reason the registration couldn't happen?
that's what they claim, but I've never heard of that personally. And I've recorded many documents. That's a separate office and a separate issue. And they did collect taxes. They could have paid, whatever they collected to the district, but they instead, withheld that money. Maybe it would have satisfied the district, or maybe it wouldn't have. But they had an estimated amount on the settlement sheet that they, as the, purportedly the experts on handling that escrow duty of collecting and paying taxes, was their determination. This is what we're going to collect. This is what we're going to pay. If it didn't work out because of tax classification, that goes to payment of the taxes, but it doesn't go to payment, doesn't go to recording the deed of trust and issuing a title insurance policy. And I don't think there's anything in the record. If that's their defense, I would think they would have a burden of having something in the record saying we couldn't record, from someone's third party saying, no, we would not accept recording a deed of trust if there was some separate issue about tax classification. So again, that's not something that my client would, my client's expectation was, I paid what you told me to pay, and you didn't do anything, as far as I can tell. And now you're blaming it on tax classification, but they're not interrelated.
Okay, no one else has any more questions. Thank you very much, Mr. Crickman, and thank you to the council for the appellees for your briefing and your arguments today, and the case will be submitted.
Thank you very much.
And log off. The next case on this morning's calendar is number 21 BG 656 in Re Pamela Stewart.
Good morning, Your Honors. May it please the court. I am Pamela Stewart. I've been a member of the bar of several jurisdictions since 1973, or actually 1974, when I was first admitted in New York. I appear before you petitioning for reinstatement to my membership in the District of Columbia Bar. This court was empowered by Congress to make rules governing this procedure. And what happened in this case is, I think, a cause of great concern, not only for me personally, but should be for the entire bar and this court. The Office of Disciplinary Counsel admits at page 32 of its brief that it undertook to independently prove what it considered the nature and circumstances of my misconduct, that expanded well beyond what the Florida Supreme Court stated in its opinion and the consent judgment that I agreed to there.
Can I ask you your overall position about that? So do you really think that in terms of the first of the Roundtree factors, the nature and circumstances of the misconduct, that the inquiry of, the hearing committee or the board, and in some cases, in this court, is limited to exactly what was found in the earlier discipline, either by, in a reciprocal case, the originating jurisdiction, or in a original case in this jurisdiction, by what was found by the court, let's say, ultimately. So it's just exactly what is found and nothing more. Is that your position?
I believe that the investigation, based on this court's precedents, are limited to the factors or the facts that were found to be misconduct. In my case, it was.
Well, so I just want to make sure. So if I take it, you were saying yes, but then I'm puzzled by the following. I mean, your submission in this court and your petition for reinstatement isn't limited. I mean, it's not as though, you came to the court saying, okay, the only thing you're going to know about the nature and circumstances of my misconduct are exactly what the Florida Supreme Court found or accepted. There's a lot of other information that you were attempting to provide about the circumstances that your position were explanatory and mitigating and exculpatory. So I'm just not quite sure how this all fits together. If really that first factor is exactly what was found, nothing else, that would mean an applicant who was coming in seeking reinstatement. It seemed like it would logically mean that an applicant who was coming in seeking reinstatement wouldn't be able to say, well, let me explain. I have some things I can tell you now that are, weren't found at the time of the original discipline. And so is it really your position, or do you think it's asymmetrical so that the disciplinary council is bound and limited solely to what was found, whereas an applicant can come in and provide additional information about what was perhaps exculpatory or mitigating or explanatory?
I believe this court's precedents and the rules that were in effect at the time said that a petition for reinstatement should be simple, and that it is supposed to be directed at current fitness. I do not contest that the disciplinary council was entitled to look into the circumstances of why I failed to account for 10 of the 16 years of my service as trustee, and why I overborrowed and the extent of my overborrowing. I have no problem with that. What I do have
just to try to again understand your legal position. I gather you don't think that either you in seeking reinstatement or disciplinary council in opposing reinstatement were limited to the circumstances that were found by the Florida Supreme Court. And the question, and I get, so is that right? Is that correct? You think neither of you were flatly bound that narrowly? Is that, am I right in understanding your answer to that, is that neither of you was so bound?
Judge, perhaps I can illustrate what I think the problem was.
Well, for sure, but I'm just trying to get an answer to a legal question, really. And if you want to illustrate afterwards, but I just want to make sure I understand your answer. Is it correct to say that your position is that there isn't a flat prohibition? There may be limits and they may have been violated here. I understand that you may be going there, but I just want to make sure at the outset. At times it seemed like your suggestion was at least disciplinary council was just whatever you can find in the Florida Supreme Court decision and the guilty plea that was its predicate. That's all they could have brought to the attention of this court. And I think I hear you saying your view is not that narrow.
No.
And so then the question is, what's the line?
I don't think that they were entitled to relitigate the civil matter in Florida, which they proudly said at page 32 of their brief. No, yes, that they did, in effect.
And so just to be, on the one hand, I gather both you or other attorneys who are seeking reinstatement can come in and say, well, we know it was found in whatever the original discipline determination was, but I have more information about the first round true factor, about the nature and circumstances. I want to bring it to your attention. That's okay sometimes for both you and for disciplinary counsel. And you've said now what you think disciplinary can't do is relitigate a civil matter. What's,
or
why,
bring it.
why not? What is the limit? Why can't they, how would you articulate in some legal terms what it is that is okay to do here and bringing new attention on both sides of the equation to the attention of the court and the disciplinary adjudicatory bodies?
Well,
What line? Because I again say it's not obvious to me why they can't relitigate it. Why can't they do whatever they want? What the word relitigation doesn't make me think, oh, that shouldn't be okay. So what is it that? How would you articulate what the limit is?
let me direct the court's attention to what this court previously said in the Maxwell and Ditton cases. And it really is a matter of the burden of proof that applies in a disciplinary case, which is clear and convincing evidence, whereas in a civil matter, the burden of proof is by a preponderance. But also,
Well, just to, there are two different, so this may get into what you mean by the word relitigate. Part of the way that the disciplinary council sought to shed light on what it was viewing as the nature of the misconduct was to call live witnesses who testified about things that happened. And none of that really gets into the question you have about burdens of proof and the like. So the point you're making now, which seems to be about burdens of proof, it seems to be a little bit narrower than the general topic of what kinds of things are available. It's more about how can they be proven.
well, yes, they did produce witnesses who, because they were not as personally involved as I was in the matters under consideration, created problems in the record. But I note that they were not presented on the main issue, which was, what is my present fitness to practice law? They were merely there trying to do their best to collect on a civil judgment. And I understand that, but this court has a supervisory responsibility in these matters. And I read from the cases, the prior cases, which are supposed to govern these matters, that the kind of extensive litigation of a civil question that I was forced to engage in is not what this court or the Congress intended when it gave this court supervisory responsibility over reinstatements and discipline.
You were starting to say that what you have a problem with was, and then a question interrupted you. What were you going to say? What exactly do you have a problem with in terms of what disciplinary counsel presented at the hearing or argued in its briefs?
A lawyer who is undergoing a proceeding with this system has a right to rely upon this court's rules and this court's precedents. And I prepared my case and my witnesses to address what I was led to believe by those rules and precedents were the issues in the case. I was not advised in anything that matters that were not public, for example, in the Florida investigation. And I checked just recently, and the only things online in my case in Florida are the consent agreement and the order of the court. That's it.
But does online to you mean public or?
Yes.
I mean, if it's not online, it's not public?
Well, I assume based on the rule that somebody could write in and request a deposition copy or something, but it is not made public as a matter of course.
Can I ask you about you seem to be making a notice argument, and disciplinary counsel responded to that argument as it was presented in your brief by pointing out that in an answer that they filed, they said that they intended to rely on the record of the reciprocal discipline and the underlying civil and disciplinary matters. And so why do you think that wouldn't be adequate notice to you that they weren't going to limit themselves to the face of the Florida Supreme Court docket documents, and they were taking as a broader inquiry? Why wasn't that adequate notice?
Because this court's precedents would not allow that kind of thing.
And what precedent do you specifically have in mind that would foreclose that?
The Maxwell and Ditton cases, the Stanton line of cases, which clearly say that reinstatement case is not a forum for relitigation of the original discipline. And
relitigation is a somewhat ambiguous term. That's often said in settings where someone seeking reinstatement is sort of denying that there was misconduct and is trying to kind of undercut the prior determinations, which I think in disciplinary counsel's view is part of how to understand what you were doing. I know you don't perceive it that way. But I don't know that those cases suggest that you are, again, back to this question of what limits there are on trying to flesh out the picture under the first Roundtree factor of the nature and circumstances. And I mean, it was clear that from your reinstatement application that you intended to provide a bunch of information about what you understood to be the nature and circumstances that were well beyond whatever was in the findings of the disciplinary authorities. And so that also seems relevant to notice. I mean, I think if part of your reinstatement petition is, let me tell you more about the nature and circumstances of how I got disciplined, I would have thought it might have been pretty predictable that disciplinary counsel would want to say, well, if we're, while we're on that topic, here's our view about those circumstances more fully understood. And, then their notice would point you to where they were going to go, which would be the information developed in the civil litigation.
Well, they went well beyond that, though, Your Honor. If you look at the Stanton line of cases, the Stanton line of cases, in my view, would not have permitted them to bring in matters involving my mother's trust, which was never a subject of any kind of discipline. And my mother was deceased, of course, and wasn't available to defend what she did. It would not have allowed bringing in the entire civil record from the Indian River County Circuit Court proceedings and the judgment or the order of the judge.
And why not? Just could be more concrete about why you think that.
Because again, the differences in the burden of proof are important, but I would also
before you move off burden of proof, I mean, your opponent responds to that by saying the cases that you are focused on and citing are cases that involved original discipline, where disciplinary counsel bore the burden of proof by clear and convincing evidence. And in a reinstatement setting, the burdens are shifted so that if there has been a prior determination by a preponderance that's adverse to your reinstatement, that the kind of concerns about relying on prior determinations under an inadequate standard of proof don't carry over. What's your response to that line of their response?
I would bring to the court's attention my criticism of the proceedings in Florida and present a warning to the court about what happens in other jurisdictions. In my particular case, the judge actually made up testimony in his order to fit his theory of the case. He took jurisdiction over my properties interests that were not raised in the complaint and the court therefore under Florida law had no jurisdiction over them, and he ordered them transferred to my sisters. I hope the court will consider that in looking at the issue of restitution, which the Florida court could have ordered under its applicable rules, but chose not to do so because the conduct in this case was not one where I converted assets of the trust, but rather withdrew them under a belief, a good faith belief that I was entitled to do that.
Disciplinary counsel suggests that this court should adopt a policy. I don't know whether they mean going forward or in this case, but let's assume in this case, that would require you to seek reinstatement in Florida before seeking reinstatement here, or before you could successfully seek reinstatement here. I assume you disagree with that. Why?
I do for two reasons. Number one, I think it's unconstitutional under the Privileges and Immunities Clause of the 14th Amendment. And I direct the court to the New Hampshire, Supreme Court of New Hampshire versus Piper case, which illustrates why that's a problem. The second problem is that you are inhibiting the right of a person to travel for business and personal reasons. And the Florida courts did not treat me very well. I would like to go back there. I'm planning to go for a former client's birthday party in a couple of weeks, but requiring me to go back there to become reinstated and go through this kind of a proceeding when I may not have a place to live or practice. And I don't think that is an appropriate policy.
Okay, thank you, Ms. Stewart. We'll give you a few minutes on rebuttal.
Thank you.
Good morning. May it please the court. My name is Ebtahaj Kalantar on behalf of the Office of Disciplinary Counsel. As trustee, the petitioner wrongfully took over $1.5 million of the trust, which she used to pay her personal expenses. The undisputed fact is that since she was suspended in Florida for this misconduct, she has repaid none of it. In fact, the hearing committee found that she has strenuously, quote, strenuously objected to doing so. And she believes that she does not owe any real
Do you agree
restitution.
that restitution is due from your perspective sort of as an ethical matter, but is it required legally under anything that's happened here?
I think that it's required under the Roundtree factors. The third factor being the steps that the petitioner has taken to remedy the past wrong. It also, we have cases such as In re Morel. That case actually strikes it bears a striking resemblance to this case where Mr. Morel was sanctioned for, I think, taking something around $1.5 million from the victims, and his petition for reinstatement where he did not recognize the seriousness of his misconduct and where he essentially did not recognize that any restitution was owed. The court denied that petition for reinstatement essentially as a matter of law. And we don't believe that necessarily this court needs to go there because the petitioner has failed on all 5 Roundtree factors in this case. And we had 7 days of hearing, 10 witnesses, thousands of pages of substantial record evidence to support the hearing committee's findings. The court doesn't necessarily need to go there in terms of ruling as a matter of law, but to your question, Judge Beck, with your honor, this is a case where the most severe aspect of petitioner's conduct was the taking of $1.5 million, and she hasn't repaid a penny of it to the trust.
Can I ask you just to follow up on Judge Beckel's question? Is it correct that there is, leaving aside sort of the ethical question of if you took money that you weren't entitled to and you need to, you should pay it back, and if you don't, that reflects poorly on an effort to get reinstated. I get that line of thought. But is there, in fact, an unsatisfied judgment, so that there's a, under Florida law, a legal duty to have made payments that haven't been made? Is that correct, or is the Florida judgment satisfied?
Your Honor, there was a deficiency judgment in Florida, which is it's in the record evidence. I forget the citation exactly, but that Florida deficiency order, I believe, said that she's liable for something north of $1.7 million, and that's even crediting her second home, which was in Florida. It was a beach house near where her mother lived, and the court credited against that. I think it was actually north of $2 million. They credited that house against that final judgment. The petitioner had been tying up that one property that was essentially the largest means of repaying the trust. She tied it up in litigation for years until just recently, when there was a final judgment, essentially putting her many challenges to rest. And that actually happened during the litigation of this case. But I do want to refocus the court a little bit to the fact that in this case, it is the petitioner's heavy burden to prove her rehabilitation and fitness by a standard of clear and convincing evidence. And this court must exercise heightened scrutiny. And I just want to
Can I ask you about that? Are you referring to the doctrine that if the nature and circumstances of the misconduct are sufficiently grave, then the remaining four factors get heightened scrutiny?
Yes, Your Honor.
My recollection, so please correct me if I'm wrong, is that the hearing committee didn't analyze the case that way and tap into that line of cases. Am I misrecollecting, or?
I don't recall exactly, Your Honor, but we do. The petitioner's misconduct, the hearing committee did note that it was related to her practice of law. The hearing committee did find that her misconduct was serious. So we submit that the findings are in place for the court to exercise its heightened scrutiny in this case. And just before I go any further, I do want to address some of the points that the petitioner made, which I think that they're it really has no bearing on this case because the standard of proof is flipped essentially. And Ms. Stewart also mentioned the In re Stanton line of cases. If I recall correctly, in those cases, the petitioner, essentially what the petitioner wanted to do, the petitioner had, I think, applied maybe 3 or 4 times for reinstatement. And what the petitioner wanted the court to do was essentially strike their order of original discipline, suspending the petitioner. And so that's why the court was saying, we are not going to revisit and relitigate our original discipline. And so I did want to just clarify that point. I just, with the rest of my time, unless the court has any questions, I did want to just touch on some of the Roundtree factors as the hearing committee found them to have not been met.
I guess I want to ask you at least some abstract questions about the first Roundtree factor and what limits you think, if any, there might be. And so, I mean, again, the Roundtree factor is worded pretty generally, the nature and circumstances of the misconduct. Do you think there are any limits on that? Let me give you a hypothetical. If somebody was disciplined for a relatively minor, the finding of the rule violation, let's say in a regional discipline matter in this court to make it simpler, for a relatively minor infraction, and then was seeking reinstatement, although it would have to be not too minor or else you wouldn't be in the position of seeking reinstatement. And then disciplinary counsel came in and said, well, it's true, that's what was found, and that's that was what was charged, and that was what was found. But wrapped up in that was intentional misappropriation of funds, and nobody found it, but it is part of the nature and circumstances of what was found. Is that okay, or are there limits on what all can be brought in under the nature and circumstances test that is different from what was found exactly?
One could imagine a situation where essentially there's an introduction of sort of an unlimited amount of unrelated
I'm
evidence.
assuming it's all. I'm assuming it's related. Assume that it's fair to say they actually were entangled, but the respondents. Let's say the respondent in that setting, the applicant seeking reinstatement. So respondent might not be the correct term, I guess. Responds by saying, "Well, I mean, maybe that let's assume that might or might not be true, and let's assume that it might or might not be kind of pretty much entangled with what happened. But it wasn't what I was charged with. It wasn't the original discipline, and now they're trying to essentially, in the reinstatement setting, have me found guilty of things they could have charged originally. They didn't charge. They didn't prove. Back then, they would have had the burden of showing it by clear and convincing evidence. Now, if reinstatement, it's sort of maybe I have to negate it." So it seems to me that there are some fairness issues that could arise depending how broadly or narrowly you interpret this idea of assuming you can go beyond exactly what was found, how far beyond you can go.
I think, Your Honor, we addressed this in our brief, but In re Hines, I think, probably provides some of the best language in terms of how far disciplinary counsel can go in rebutting a case. The court there said that fitness extends to the full range of the attorney's professional and personal conduct. A determination of an attorney's fitness to practice can only be made by viewing the total picture of the professional conduct. So Your Honor, I think my answer to your hypothetical question would be enough evidence to provide a total picture of the misconduct. And to sort of bring it back to what happened in this case, the hearing committee, first of all, they did hear the petitioner's many arguments on trying to keep out disciplinary counsel's witnesses, trying to keep out bank records, court records, essentially doing everything in her power to limit disciplinary counsel's view of what the actual misconduct was. And the hearing committee rejected that. As the hearing committee stated, the reinstatement cases are centered on the nature and circumstances of misconduct. And in Yum, this is of primary importance. So this dictated, I suppose, how much energy and resources were dedicated to this. And it's important to note that in the Florida discipline itself, in her conditional guilty plea, it actually states that Judge Kanarek found that the petitioner breached her fiduciary duty by failing to provide the accountings, by over borrowing, and that her request for fees and expenses were denied. And so I don't think it's a stretch at all to be able to take a look at Judge Kanarek's findings, to understand what they said, and to challenge the petitioner's many mischaracterizations of what happened in Florida as a part of her reinstatement. And I won't list off all the many mischaracterizations. But I mean, for starters, she contended repeatedly that her conduct was lawful. When her own stipulation, the Florida violation that she stipulated to was that she engaged in conduct that was unlawful or contrary to honesty and justice. And so her repeated refrain that everything she did was lawful, that everything she did was reasonable. Disciplinary counsel put on a case to rebut those claims. It couldn't take, simply couldn't take it does not need to take petitioner's word for it.
The language you read to us a few moments ago, which focused on the full range of professional conduct, what's the answer to this question? If someone were to say, yes, but much of what was involved here was not professional conduct, professional as a lawyer conduct, it was conduct in connection with her father's trust and her role in administering it. So how do you get to look at all those things? What's the answer to that question?
Yes, Judge Thompson. The answer to that is petitioner's own stipulation. The other violation, the only other violation that petitioner stipulated to in Florida was a violation of Rule 8.4D, essentially, Florida's equivalent. And that rule states that it prohibits a lawyer from engaging in conduct in the practice of law, and it says it right there in the rule, that is prejudicial to the administration of justice. So she stipulated that she violated, that her violations involved the practice of law. And there's also plenty of evidence in the record to support the hearing committee's ultimate conclusion that what she did was in her practice of law, such as she, for instance, she, at some point she's telling the co-beneficiaries that she's owed fees as personal representative, as a trustee, and she says, I'm also entitled to extra fees as the attorney. Really, what petitioner was doing was using her knowledge and her role as an attorney to muscle out her co-trustee and to, as the hearing committee found, to essentially keep away as much information as she could from these co-beneficiaries and to conceal her activities. So Your Honor, her role as an attorney is wrapped up in this conduct, and you really can't pull it apart. Now, the hearing committee found that not only was this misconduct serious, but that it was, quote, very clear that petitioner does not recognize the seriousness of her misconduct. She has paid some lip service to some of those violations that she's stipulated to. However, the hearing committee found that she has, quote, completely denied breaching her fiduciary duties. Substantial record evidence supports this. She testified that her conduct was reasonable, as I stated, legal, and that in fact her father would have approved of her work. She also stated that she stated to others publicly that her suspension was no fault of her own, that it had nothing to do with her practice, contrary to her own stipulation, and it was her family that connived to destroy her practice. And petitioner continues to make certain false claims. For instance, she continues to claim that she paid $700,000 to the trust at some point during the trust administration. So this is before she was suspended. The hearing committee found that this is just not true. She sold the commercial property. She took $500,000 from the proceeds of that sale. She put it into an account that only she had control over. And she spent that money immediately. But she's repeatedly said that, well, I paid that money back to the trust. I just had to reborrow it. And significantly, the hearing committee found that petitioner has taken no steps to pay back the trust. She continues to claim the hundreds of thousands of dollars worth of fees and expenses that she believes she's entitled to, even though she stipulated as a part of her conditional guilty plea that she was denied those fees and expenses. And the hearing committee interpreted that also as another facet of petitioner's refusal to acknowledge the misconduct here. And petitioner, another false claim that petitioner continues to make is that she's just unable to repay the money, but that's not true. The hearing committee found that she made over $125,000 in income around the time of her suspension. Instead of paying the trust, she's paid the Kenwood Golf and Country Club. She's paid tens of thousands of dollars to the Cosmos Club, or between those two clubs. And she's testified that the judgment is essentially so enormous that whatever she pays won't make a dent. But she has a co-beneficiary who's disabled, who relies on Social Security income. It would paying that money to, had she paid that money to her, it certainly would have made a dent. I won't go into the last two factors because I'm out of time. But we urge the court to adopt the hearing committee's recommendation to deny petitioner's petition for reinstatement. If there are no other questions, thank you very much.
Thank you very much. Ms. Stewart, we will give you a few minutes on rebuttal.
Thank you, Your Honor. I brought to the court's attention your recent case that involved the heightened scrutiny issue. And that, I think it's Alan Deere, can't pronounce it right, but anyway, it's in my recent filing. In that case, the court recognized that the conduct was egregious, grave, etc. Whereas here, my conduct, which I never contested, was not wrong or serious. As a matter of fact, I immediately agreed to a consent judgment in Florida because I knew I had not done the accountings. I just didn't have time. I really did not. The idea I bring also
Just
to the
be
court.
clear, what you just said suggested that what you were acknowledging in Florida was only the failure to do accountings. Is that all you think you acknowledged in the Florida disciplinary matter? Or
Oh, no. The over borrowing also.
And do you understand yourself to have acknowledged in the Florida proceeding that you breached your fiduciary duty?
Yes. Yes. And it was a clear breach of fiduciary duty not to do the accounting. That was what I understood from the get-go in this proceeding. And I admitted it. I took steps to explain what caused it and so forth.
Can I ask you, you refer to the second half of that as over borrowing. Over borrowing, if you pay it back, is one thing. Over borrowing, if you don't, is another. And so do you dispute that you over borrowed and then did not repay?
No, Your Honor. However, the Florida court found, and this was absolutely true, that I expected to repay. Remember that during the course of this, I was dealing with my family. I never expected this kind of a reaction. As a matter of fact, I didn't find out until my mother died that my sister and brother-in-law didn't believe that trustees were to be paid for their work. I put in 991 days and documented 3,667 hours. I devoted over 16 years.
Can I ask you about the, you say you documented them. I thought there was some dispute about that because there were no contemporaneous records and that your or there were not, I know is probably too strong, but there were not consistent contemporaneous records. And so a lot of the documentation was sort of after the fact calculations or determinations.
Well, actually, it was not so much after the fact. It was just that while I was going through it, I did not do what I would normally do with a client because it was my family. And after the fact, I had kept every receipt. Unfortunately, my basement looks like a white tornado hit it. But anyway, I am a complete pack rat. I had all that. And the receipt showed when I, for example, got some gas on the way to the airport or whatever. So I was able to calculate what I believe to be a lot of time that I was expending on this, on these duties. And what is in the timeline is only there because it is backed up by a contemporaneous document. I unfortunately lost much time that I spent taking care of my mother and her medical appointments and so forth, and the house and going to see vendors and so forth, because I just didn't have documentation of that. So this is kind of the bottom end of the time that was spent. And as a public policy matter, I think the court should be concerned about sending a message that trustees should not be compensated for their time. I know my father intended me to be compensated because we discussed it, but that's not in the record, obviously. Another thing I think needs to be said is that disciplinary counsel's position is contrary to the court's rule in Mapp versus Ryan that the original panel that looked at me, and that it included Judges Beckwith and Thompson, when you suspended me, you made certain determinations. They argued that Judge Canarak's opinion should be, the Bible in this case, and that was rejected. So
Why do you say that? I mean, I have
I say that because of what ODC filed in that proceeding.
I'm just saying the wording of the order, just of the order of suspension, which is very brief per curiam, just says it appearing that respondent stipulated to the factual basis.
Stipulated to the factual basis.
So I just didn't see anything that rejecting anything. I saw it.
Well, in context, it rejects the idea of relying upon Judge Canarak's opinion.
Why would that be? I mean, if the order says we think, I mean, if it points to some stipulated facts as a basis for suspension, I don't know why that would in context, it might be we don't need to decide one way or another whether more than that could be done, but I'm not quite sure why I'm not quite tracking why that would be either an explicit or an implicit rejection of anything rather than what it said it was, which is here's some information that suffices to support suspension.
I believe that what the court said was that there's no need to go beyond the Florida court's order, and which incorporated the consent agreement, which had the factual basis for the plea, and that to ask this court to essentially overrule that and approve the expedition that occurred here over several years' time would be in violation of the rule of Matt versus Ryan. I also think that ODC really is inventing the idea that I was conniving and concealing in this matter. I was trying to keep my head above water, and I was available on the phone quite frequently to my sisters, my brother-in-law, and so forth. If you look at the timeline, every time I went to visit my mother, the first call I made was to my sister. So, they were well informed over this time, and I'm sorry to say their memories have faded about conversations that we had about what I was doing and so forth. I was quite transparent, and the idea that I was living high on the hog is just completely out of line. The period when I was going to eat it at Kenwood a lot, for example, was before I was suspended. I had an obligation to pay those debts. I paid my bills as best I could, but I still owe them a lot of money. And I also urged the court to look at the document that was excluded by the hearing committee, which contradicted a lot of their factual misapprehensions and with citations to the record. I provided a boatload of original receipts, copies of them, to show what I was doing as trustee and to illustrate that my services deserve some consideration. Now, the court in Florida gave that none. There's case law in Florida that says if you commit a breach of fiduciary duty, a court can withhold fees. But there's no law that says that the statute, which requires reimbursement of trustee expenses, can be violated. But the court there did that. And just as an observation for this court, in Florida, there are about as many lawyers as there are in DC. They have now 6 intermediate courts of appeal, 6. And a new one was just constituted because their caseloads are so heavy. The Florida Supreme Court has certiorari jurisdiction in cases like this. So it is not like the District of Columbia, where we are blessed with a court that is responsive and writes opinions and so forth. Anyway, in conclusion, I'd like to say that I consider it a privilege to have been a member of this bar for many years. I served long and well in the Bar Association of DC. I believe that I am competent and have met all the requirements to be reinstated. I appreciate the seriousness of my conduct, and I wish it hadn't happened. I'm pleased that my mother was able to go to her rest as she wished. And in that respect, I think I am proud that I did that job. But I am not proud that in order to do it, I cut some corners I shouldn't have cut. That will never happen again. It never happened in my prior career, but anyway, I thank you for your attention. I know that these are not your court's favorite cases, but they're important.
Thank you very much, Ms. Stewart and Mr. Kalender. Did I say that? I had that right. Thank you both for your arguments today and your briefing, and we will take the case under advisement. So. The third and final case this morning, I cannot see the clock, it's glare, but it's still this morning, is number 21 CV 511, Fraternal Order of Police, Metropolitan Police Department Labor Commission versus District of Columbia.
Morning, judges. Anthony Conti on behalf of the appellant, the DC Fraternal Order of Police. May it please the court. History teaches that grave threats to liberty often come in times of urgency, when constitutional rights seem too extravagant to endure. That's a quote from Justice Marshall. And he was making that quote and writing that in the context of McCarthy-era cases, World War II internment camps, and at the time, the drug scourge of the 80s. I raise that to frame the issue today. On May 25th, 2020, not too long ago, but it probably feels like almost a decade, George Floyd was killed. On May 29th of 2020, protests reached the White House, which was on a lockdown. The mayor had imposed curfews on the city. Monuments were being vandalized. By June 8th, only a few days later, the council had come together to craft emergency police legislation, comprehensive police justice reform emergency amendment act. It was an emergency piece of legislation. And by that point in time, the U.S. Attorney Sherwin was commenting to the council about his serious reservations about the particular component of the act that's before this court. Now, throughout that summer, there were both peaceful protests and very violent protests. By July 7th, the council had already passed this emergency act. There was no public comment. And the question that we raise as the Fraternal Order of Police is whether or not in passing this act, the component of which mandates the disclosure of police body-worn camera footage, not just the body-worn camera footage, but the immediate identification of the officer involved in a serious use of force, is something that impermissibly disrupts or infringes on the mayoral powers. And the mayoral powers in question are the duty to preserve public peace, to protect the rights of persons, to prevent crime and arrest offenders. Now, a body worn camera footage is not an ordinary document. And I know that the district wants to see it in the light of an ordinary document, subject to a Freedom of Information Act request, but it's not. It's an evidence gathering tool. It's specifically designed to gather criminal evidence.
Well, that certainly is one of its functions, but I'm not quite sure to the extent you're suggesting that's its principal or only function. I think that it's also well understood that it's intended to create a record of the nature of police activity and permit later assessment of its legality or appropriateness under various policies. Do you think that's not a purpose of it, or shouldn't be a purpose of it also?
I can tell you that's a consequence of capturing the footage, but the camera is not aimed at the officer.
Well, it'd be pretty difficult to have all citizens wearing body-worn camera footage. So fair enough.
Understood. I think the significance, Your Honor, is that when we look at the context of the mayoral powers and the removal of the mayor's discretion in arresting offenders and prosecuting and bringing to the table prosecutions, that's a very important and vital function.
You said removal of the mayor's discretion in prosecuting folks and the like, and at least not directly. The statute doesn't seem to directly do anything like that.
Well, but when the statute mandates within 5 days the disclosure of what is essential criminal evidence in many of these criminal proceedings, it removes the mayor's discretion whatsoever to make the decision in consultation with, for example, the U.S. Attorney's Office.
It certainly removes the mayor's discretion about whether and when to release, or limits it. There's an exception and but I think it generally removes the mayor's discretion about whether to release the relevant information about body-worn camera footage. But I thought you were suggesting that it was invading the mayor's discretion in a more expansive way with respect to the mayor's discretion about, the mayor in at least some cases in the District of Columbia wouldn't have discretion about who to charge, but would have discretion about at least who to arrest.
Correct, but wouldn't have the discretion about whether or not the release of that body-worn camera footage might jeopardize that prosecution. It's within 5 days before the matter can even be fully investigated, before an officer can even be investigated for whether or not the use of force was appropriate, it's released publicly. And so, yes, that takes away some of that important mayoral discretion. And not just that. What if a mayor determines that the release of body-worn camera footage might incite more rioting and violence in the city? The fundamental duty of the mayor is to preserve public peace. That's a constitutional duty. And how is the mayor able to exercise that discretion when discretion is removed? If Mayor Bowser believes.
Can I ask you, I was just thinking, for example, of the civil rule, the criminal discovery rules, which are promulgated by the court and impose on the district and local prosecutions, the U.S. Attorney's Office and federal in prosecutions prosecuted by them, various obligations about disclosing information, and it doesn't give any discretion to the mayor in any of that. And if some of that information, I'm quite sure, could have, it's release and discovery could have implications in various ways. But are you saying that all criminal discovery needs to be in the discretion of the mayor, subject to concerns about the extent to which it might interfere with public safety by way of triggering riots or the efficacy of public prosecution?
Well, Your Honor, I think that's Kingsbury. And I think it's important for the court to look carefully at the Kingsbury decision because, look, I'm not a criminal prosecutor. I'm a civil attorney, but just in reading Kingsbury, it's quite clear that courts on a regular basis deal with body-worn camera footage. And Kingsbury discusses the release of that footage, extracting certain information from that footage when turning it over to defense counsel. And so in Kingsbury, this court recognized that there is a privacy interest that police officers have in not being identified, just like some witnesses have a privacy interest in not being identified. And even as important as it is,
You seem to be shifting a little bit from what you'd previously been focused on, which seemed to be a separation of powers. line of thought.
that's correct, Your Honor.
Okay, I just want to make sure we're. so
Certainly,
you're
that's
moving
the
off
due
separation of
process
powers and now
component
to
of the
due
argument.
process.
Absolutely. But to respond to your question, you're right, there are obligations, but they are carefully regulated by the court. And here's the problem. Not only has the mayor been taken out of the equation and she has no ability to decide that it might not be in the city's best interest to produce this body worn camera footage in 5 days, but the courts are denied any meaningful review of that. If the statute is not discretionary and it's mandatory, how does a court review that without throwing out the statute, which is why we're here, because it's the only way the court can review that. If the statute mandates, even if riots will ensue, the mayor has no discretion to release a body worn camera footage in 5 days of the incident, court can't review that unless it finds that the statute is infirm. And so,
some of the arguments you make are, policy arguments that one can reasonably press. And I think the council and the mayor who signed this legislation, it's a moving target. So I think we're now under temporary legislation through March, if I'm oriented on all that, but which I think the mayor signed. There are other policy considerations about transparency and the like that are countervailing, and it's normally up to the legislature to weigh a lot of public policy considerations, and there's sort of shared responsibility. The mayor and the executive branch have responsibility for sure to enforce the laws, but the DC Council has responsibility to protect public safety and enact legislation that is in the interests in the view of the DC Council and in the mayor when the mayor signs the legislation that is in the interest of the people of the District of Columbia. And it's a little hard for this court to jump in the middle of that and say that this provision is somehow categorically out of bounds for the DC Council and the mayor to enact this legislation. What's the closest case you can think of where a court has said legislation has been enacted in an area where there is important executive branch responsibility, but this is just outside the bounds of what a legislature can do in an area like that? I mean, do you have an analogy that could give us some comfort that we wouldn't be out on our own if we were to agree with you?
well, I think the issue is it's rare that a legislature removes all discretion whatsoever from a mayor in an important function like this. Where I think the cases, and I will concede most of them deny a separation of powers claim, but where the cases seem to come down is when the legislature either continues to exercise control. I think Morrison was the Supreme Court case on that, but where the legislature continues to exercise control or removes any and all discretion from the executive. And it's rare, but when
if you're going to point me to a case where a statute was struck down on separation of powers grounds because the legislature established a flat rule in an area where I tend to think there's sort of shared responsibility between the executive branch and the legislative branch in terms of, protecting public safety, enforcing the laws. Where would you, that strand of sort of, this is just the legislature set a flat rule in this area rather than leaving it to case by case determinations by the executive, that's on the wrong side of a separation of powers divide. That seems to be a strand of your thinking. I'm just wondering what legal support you might point us to for the idea that that can be a ground on which to invalidate a statute.
Well, there's not a particular case in DC. I think the closest that this court came is Bergman, and that was a challenge, Bergman versus DC, and that was a challenge to the anti-runner legislation, ambulance chaser legislation brought by an attorney claiming that that overstepped the judiciary's function and regulation of the bar. And this court said that, and this is as much of a standard as I have, but that when looking to determine whether or not there's an infringement, the court has to look to whether or not the legislature has infringed in any significant way on the judiciary in that case. And this court found it didn't. But what I would suggest is that what has been enacted is a significant infringement on the mayor's power. And again, I remind the court that if the mayor were to determine that she could not properly carry out her functions of protecting the public and the peace and decided that it would be improper to release this, there would be no ability to challenge it to this court without striking the statute.
The arguments that you make in your brief, do they, in your view, all apply equally to the release of the body worn camera footage and the release of the names of the officers involved? Is it how those things work together, or is it that separately they cause problems?
It's a good question. I think that as to the separation of powers issue, it is probably more specifically the release of the footage itself. Whereas as to the due process challenge, it's the combination of the two. Because, and I'd like to get to the reason for that on the due process component. Now we're talking about a fundamental privacy right. And what is affecting that privacy right is not just the release of the camera footage, but contemporaneously the release of the officer's name that's involved in the serious use of force.
How are the names released, by the way? I looked on a website and I could see a video that shows officer use of force, serious force, and I saw another that involved an individual who was shot and killed by police. And one thing I noticed about both videos is that even though the officers presumably were wearing name badges, you really couldn't see them, and names were not mentioned, and faces were pixelated so that you couldn't see them. And I think on the video that I looked at, an officer gave his name, Sergeant, whatever it was, no first name. And that's what got me to thinking about how these things work together. So I guess I know how the videos are released. They're released onto a website.
Yes.
I don't know if they're otherwise released as well. What about the names? How are they released?
My understanding, and it's a good question, because when I have reviewed the videos, I had heard the officers' names in the instances, but
I imagine it could differ
yeah,
from video to video, but
my
the particular one I saw, they were not.
my understanding is that they're released through the, and I don't know if Your Honor was looking at the MPD's website when reviewing those, but the Metropolitan Police Department publishes that. And I believe that they publish the name either when they sort of do a sound over describing the incident.
They do.
And I had thought that I had heard the reference to the name there, and it may be published otherwise, but I know for certain our members' names are put out there publicly. I also know it's not always that easy to find everything.
The sound clip, because you're right, the video I viewed was preceded by a little narrative that
Correct.
was both that you could hear and read on such and such a date, this occurred at such and such a location. Is all of that released within the 5 days along with the video, to your knowledge?
Yes, that's been the practice. And I'm not saying that that's required or not required, the narrative and sort of the production that they do, but they do it. And that has been the routine practice since the enactment of this legislation.
Can I ask you a question? Before this law, I take it, and correct me if I'm wrong, the mayor had discretion to release these videos if she wanted to. Is that a violation of your members' privacy rights?
Well, I think that it's the combination of the two, because you're correct that in the past, the mayor had the discretion. Now, timing has always been important. And, you know, I would say 5 days would be relatively unprecedented because as U.S. Attorney Sherwin's letter that was written to the council references, this can seriously compromise criminal prosecutions.
It seems less about privacy and more about whether it's good or bad policy, and maybe depending on, you know, maybe it spins out into your separation of powers argument a little bit. On the privacy side, I'm not sure why the timing would matter or the discretionary nature of it would matter. Why are those relevant to whether such release offends a privacy interest or more than a privacy interest, a constitutional substantive due process right?
Certainly. I think timing is important for a number of reasons. From the standpoint of an officer involved shooting, we presented an affidavit of Beverly Anderson, who is the chief clinical psychologist with the MPAP, which is the Employee Assistance Program that counsels officers regularly and you know, after one of these serious use of force incidents. And what her affidavit stated was that in that immediate aftermath of an officer involved shooting, officers are most vulnerable to trauma.
I mean, I understand why it makes a difference in a variety of ways. What I'm a little less sure about is why it makes a difference to whether there's a substantive due process right to privacy. And is your idea that the privacy interest the privacy right that you're identifying is tied to the timing and the adverse consequences, so that if, let's say, this was done 6 months later, there would be no substantive due process privacy interest, and it exists only because this is done quickly and in a way that might have adverse consequences for the people depicted?
Well, it's a good question, and I think if the court, you know, sort of frames this, our primary case that we would ask the court to review carefully is NASA versus Nelson, and what that court says without deciding is that there is a privacy interest involved when the government collects information, including names, the identity, and information about these individuals, and then discloses it. Now, in NASA and in Wayland, which NASA relied on to suggest that there is this fundamental privacy interest, in both cases.
The word fundamental and the word interest got me a little confused. I mean, I doubt anybody, well, I guess we could find out, but I doubt anybody would dispute that there is a privacy interest. The question is whether there's a substantive due process right, and the word fundamental. And the Supreme Court definitely, as you're acknowledging, did not find in NASA and has not found that there was an actual substantive due process right to protection of information.
Correct, but what it said was we assume for purposes of the analysis that there is, and then it went on to analyze. And what's important about that is when it analyzes it, and if there is this right, what the legislature is required to do is abide by strict scrutiny standards, which means narrowly tailored. And that gets to your honor's question.
Got it. But let me just, to back up to the fundamental starting point for this line of argument, it seems like an uphill struggle to say there is a substantive, constitutional substantive due process right to privacy when you are a public official. And the question is, information showing what you did as a public official and naming you as the public official who did it. I mean, the word public in all of that and the word privacy seem at a kind of war. So whenever there might be a right to privacy, can you help me with how that would work with public officials performing their duty?
It's a good question because there is that give and take. And I think the FOIA cases are instructive. And I know what the court will say, well, that's FOIA. And FOIA has standards and we abide by the standards. And so if we found a privacy right in a FOIA case, it's because we're asked as the court to weigh in to balance that. But I think, look, FOIA has developed and now there is this insatiable appetite for everything that the government does. And so a lot of the case law has developed under FOIA, but I think it's instructive. And I think it's instructive because what FOIA teaches is that there is a way to narrowly tailor what might be important information about how the government operates but doesn't overstep and infringe on every single employee's day-to-day activities in government, their personnel
I guess I'm
records.
just asking, I guess my question, one way of looking at it is, why isn't it right to say, in my capacity as a public official, I have zero constitutional substantive due process right to informational privacy about that I am the public official who took various public acts and showing me taking those acts as part of my official duties. Why is that not the right conclusion? It's not obvious to me why I would have any constitutional privacy. I might have a privacy interest that might be cognizable in various settings, but in terms of a substantive due process right, it just seems like a tough road to hoe.
Well, the Supreme Court cases that have discussed the issue talk about the government in the context of information gathering, and the government, even when it deals with an employee, is gathering information. It might be something in a personnel record. It might be a background check. It might be a drug test result, and it might be video surveillance of that employee.
I certainly take that the government could gather information about a government employee that would implicate maybe privacy interests to a very strong degree. Background checks are a good example. But if the issue is naming somebody as the public official who was performing certain public duties and depicting the person performing those duties as a public employee, I do have a hard time getting my head around what privacy interests exist at all.
Understood. And that's what NASA and Wayland deal with. The idea of the government gathering the information in both of those cases did not offend due process. But what both cases analyzed was the reason it didn't was because the government wasn't disseminating the information. And that's where the line becomes drawn by the courts. And I would say we stepped over the line here because not only has the government gathered the information, but they're disseminating. And now when they are affirmatively disseminating the information, it has to be narrowly tailored.
So do you think that to the extent Metropolitan Police Department has somewhere a public list of all its officers, you think that's constitutionally suspect and would have to be narrowly tailored, so that there has to be like a compelling state interest for having that publicly available?
No, because I think that
That's disseminating information. It happens to be the names of people who are public officials, but it's public officers.
certainly. And I think no, I think that, I mean, as we all are aware, all public official names are public record.
I guess the question is, why isn't it public record in the same way? Which public official did which official act, and a depiction of the public official taking that public act?
Well, I think you have to put it in context. If I were to say, Judge McLeese sat on the court today, it's not offensive. But if I were to have a video recording of something that Judge McLeese is alleged to have done that's improper, and I immediately release it without providing him with any opportunity to respond, and there's no investigation of it, then I think there are privacy interests implicated. And perhaps
nowadays we're actually on, it's like we have body worn camera footage, and this is being released without discretion immediately. So if it's embarrassing to me, which I'm sure it is sometimes, there's nothing I can do about it.
It's in the context with the conclusion, a publicly made conclusion that this was a serious use of force incident, which carries with it significant implications. And so I think the context is important. And we've provided just some of the evidence that we presented to the trial court, where these officers online were being threatened. They were asking for their family's identification, the identification of where their children went to school. I think it's a little bit different than just publishing the name of all officers. And again, it's where I say it may be permissible and it may be necessary in the context of a criminal prosecution, in the context of just the public having knowledge of the information. But it's that component of discretionless, automatic, 5 days, it's published. I think that context can't be ignored, both from the standpoint of the due process challenge, as well as the separation of powers challenge. I've exceeded my time, but I'm happy to answer any questions.
Thank you very much. We'll give you some time on rebuttal.
Thank you.
Good morning. I think we're still in morning. Good morning and may it
Yeah.
please the court, Megan Browder for
Can't
the
see the
District of
clock.
Columbia. I just want to take us back a little bit because I think appellant here leaped over, went straight to the merits, and I want to take us back to one of the threshold issues in this case, which is standing. Appellant does not have standing to challenge the council's policy determination that a narrow subset of body-worn camera footage must be publicly disclosed more rapidly than other public records. And even if there is standing, there are significant issues on the merits, as your honors pointed out. Beginning with standing, the allegations in the complaint are insufficient for organizational standing. Appellant argues that they'll have to expend more resources to publicly defend and to challenge improper transfers of detectives. I would note this, the second justification here is highly speculative. It relies on an attenuated chain of events, as the trial court stated. Even on expending more resources, however, this is not a concrete injury for standing purposes because there's no allegation in the complaint of what they're diverting resources from and what they would be diverting them to. So we know that they allege they would be publicly defending its members, but we don't know where those resources are pulling from and how that's going to impair their mission. There's no direct conflict here between the alleged unlawful conduct and their mission as well. Then I think even if we surpass that hurdle for finding a cognizable injury, it's not redressable by this court because, as your honors have stated, the mayor has the ability to release this footage, whether or not Section 103 is in effect. And she has released this footage. This footage has been on a rolling basis, been released at least since 2016. And even before there was mandatory release provisions, the mayor—
She released it within 5 days.
not within 5 days, your honor, but in 2 instances within 10 days and 1 instance within 16 days. And I will note, one, that the affidavit from the clinical psychologist that appellant relies on doesn't give a particular number of days. It doesn't say 5 as a magic number. It says in the immediate aftermath. And I would count within 2 weeks as part of that immediate aftermath. So whatever injury that may happen from a mandatory release also will happen from a discretionary release. Second, your honor, I would state that even though the statute says 5 days, a lot of times it doesn't end up coming out within 5 days because we have to get next of kin consent if there's been an officer involved death, and that can take some time. So I think even when the statute is operating and there's a mandatory provision, it's not always within the 5 days. So if there are no further questions on organizational standing, I also don't believe that appellant has stated a claim for associational standing. There's no certainly impending injury here. And I think the biggest hole in the complaint here is, again, these videos have been—
You said there has to be a certainly impending injury?
Yes, your honor. Certainly impending or substantial risk, I believe is
that's where I was just trying to think back. I haven't gone back to look at this case, but there are like old Supreme Court cases like Claiborne Hardware that involved dissemination of information about membership in organizations like the NAACP. And just to understand your standing argument, if let's say that I don't know, the district started gathering and then was going to release information about membership in various kinds of organizations that people might wish to have confidential, and where people say, we're afraid that if that information gets out, we'll be retaliated against. And leave aside what theory of legality would be presented to challenge that action, but assume that the issue is standing. I would have thought that if, certainly at the motion to dismiss stage, that if the allegation is when this information has been released in the past, there have been threats. And so we fear threats in the future if it is, more quickly. And, again, there's your remedial standing kind of questions, but leave those aside for a minute. I would have thought, at least at motion to dismiss, that would be the kind of claim that might well confer standing. It seems like there is at least a plausible claim right now of a substantial risk of threats or retaliation. Why do we fall short?
I think the part missing from between what Your Honor has stated and what we have here is you said there have been allegations that in the past there were these threats, and we don't have that here. What we have are a handful of social media posts that we don't know who made them. We don't know when they were made. They could have been made 6 months after the release of the video. We don't know what they were made in relation to, because that's another important aspect here. It's not as if the public is in the dark about these incidents and nobody knows about it until the information is publicly released through the body-worn camera footage. People know that these incidents happen and they want to know what happened. And that was the impetus for the law: police accountability and transparency. And so all of the injuries kind of have that same fatal defect in them, and that the government is not releasing something that was previously private to the public. This is public information. These are public police officers doing a public duty. Similar to, the conversation Your Honors were having with the appellant earlier, I could say, I don't want to be on the streaming on the YouTube right now, but I don't have, there's not a concrete interest or a privacy interest there.
Can I ask you a framework question too? It was implicit in the question I asked, but to be explicit about it, do you agree that since right now we're on motion to dismiss, that the question for standing would be whether there's a plausible claim of standing that could survive a motion to dismiss, or do you think the question should be framed differently?
I think whether there's a plausible I think you have to have a legally cognizable injury.
I just meant, does the standing issue, put it more abstractly, is the standing issue in front of us to be considered through the standard applied to motions to dismiss?
Yes, I believe so, Your Honor. And I think, with that, yes, we have to assume the facts is true in the complaint. You don't have to assume legal conclusions or unsupported conclusions is true. And I would also note that since this is a jurisdictional issue, there's nothing that would have prevented or prevents the appellant from introducing additional evidence. The court can look outside the pleadings to decide a jurisdictional issue. So if there were, some sort of actual concrete harm or certainly impending substantial risk, however you want to state the standard, we don't have any evidence of that here. And I think it's just, it undermines their standing theory that it's plausible when these videos have been released since 2016 and we don't have any specific concrete evidence. If there are no further questions on the standing issue, I'd move briefly to the merits. On the separation of powers issue, Section 103 is a public records law that's within the council's domain, just as FOIA is. And yes, these are highly sensitive matters, but so are some of the matters that people ask for from FOIA and that they're able to get. And so I don't believe appellant has articulated a reason why this particular public records law crosses the boundary and crosses the line from permissible to impermissibly burdening.
Well, his focus is on the lack of discretion or any way out if there's an unusual circumstance.
But this is a shared space between the legislative and the executive. And I think the questions that we're having this morning, I think, go straight to the heart of why this is ultimately a policy dispute and not a legal dispute. The council and the executive are able to duke that out, and the people are able to vote and say, hey, since we've had these public releases of footage, there's been riots in the streets every time one of these comes out. We don't want this anymore, and vote the people out of office. Or the council could go back and change their mind and say, actually, this isn't going the way that we thought. There will be hearings on the permanent legislation. Your Honor is correct. There's a temporary amendment in effect until March 2023. And the hope is that the permanent legislation would have passed by then. On the privacy issue, there's no public employees don't have a constitutional privacy interest in what they do in their public facing duties. I would point the court to Garcetti on that. I think that's very clear that, you are, when you're doing a function within your public duty, you don't have a the same kind of constitutional rights that you would as if you were doing so as a private citizen. To Judge Thompson's point, that's correct. For the privacy interest, when you look at the videos, the officers are pixelated, even identifying marks, like if they have tattoos or something, those are pixelated. You can't identify any officer, any bystander, the person who suffered the injury or the shooting from the police is also obscured. So I think the privacy interest here just, I don't think that there is a privacy interest to be violated, but even if there were, there's no violation here. And then
How are the names released, by the way?
the ones that I have seen, so I, like Judge Thompson, the ones that I've looked at, I've not seen the officer's name released on the narrative. Generally, what I've seen is a letter from the mayor's office, generally from DEMPED or from MPD to the council to say that since this law has been in effect, saying the MPD or the mayor is releasing the body worn camera footage from such and such incident pursuant to the Emergency Act, and then it will list the officer's name.
So the release is to the council, and if the public wants it, they go through FOIA, I guess, or they.
No, I think these are generally publicly released letters. At least
see.
I've been able to find them online. And typically, I think what happens is the news media gets and so most people that find out, I think, are going to find out from probably a news story. Oh, did you have a question? Oh, sorry. So I think another important point, just a couple more points I would make. These incidents can and have been released by public citizens. So to the extent that there's any privacy interest, it's significantly undermined by the fact that any member of the public who's walking around with their cell phone, that's how we got the George Floyd video, is not from not from body worn camera footage, but from a public citizen who videoed and released it publicly. And officers also have to give their names when they're interacting with the public. So even if when the officer is approaching someone and they turn on their body, so I would make that point first, is the officer is turning on their body worn camera. It's not as if it's just a roving thing that's always on. When they approach and they are entering a situation, they turn on their camera and they give their name and their badge number. And so this is all public information that anyone, I believe, is entitled to. The last thing I would say is, even if there were a violation, there's a compelling government interest and to enhance police accountability and transparency. That's what the council relied on in their resolution and why they passed and are trying to pass the permanent comprehensive police reform legislation. And it is narrowly tailored because the only way to actually have police accountability and transparency is to have all the videos released, not just some here and some there. So if there are no further questions, I would ask.
The record reflects that when there was a bill that would have required release within 72 hours, the then U.S. attorney did object for the reasons that have been discussed. And I can't recall right now whether those same objections were lodged to the proposal to require release within 5 days.
No, I've not seen any anything that those objections were reprised when it was changed from 72 hours to 5 days. But I will in full candor say that there will be significant hearings on the permanent legislation. And I presume that, there will be opposition at that time. We ask that the court affirm. Thank you.
Thank you very much. Thank you to both sides for your arguments today and your briefs. The case will be submitted and we are adjourned. Oh, I'm so sorry. I'm so sorry. I'm really so sorry. I don't know how.
No, that's okay.
So
Just to hit on a few points. I think Judge McLeese's questions probably demonstrate that you're fully aware that this was the motion to dismiss stage. So the standing arguments that are raised, I would say that if you look at the case law, most of the case law that finds there's a lack of standing, for example, for associational standing, which only requires one member, one of our members has some either harm or there's the foreseeability of the harm. At the motion to dismiss stage, The cases where they found no standing, there have been no affidavits. There's been no evidence placed in support of the argument, at least. We did put before the court credible threats of violence. I do believe that they are timestamped, meaning they were threats directly related to incidents that were being released in at the same time or contemporaneous with this. But in addition, to say they're anonymous is accurate in the sense that they don't identify their name, social security number, and date of birth and where they live, but they are something that police authorities can and I believe have tracked down, at least to follow up on this. We also put in evidence that the MPD, ahead of this, the passage of this legislation, reached out specifically to all of the officers to ensure that local authorities could be advised to patrol their neighborhoods, to patrol their homes. These are steps that are extraordinary, and they're being taken because there was a serious and credible concern for the safety of the officers and their families. To suggest at the motion to dismiss stage, when an affidavit is presented by the chief clinical psychologist that is explaining to the court that when you release these materials within 5, 10, or 15 days, the likelihood of serious trauma to the officer who's involved in the shooting is high and substantial, is certainly enough from our standpoint to establish at a motion to dismiss stage that they're standing to bring these claims. From this, the comment that council made about this being a shared space, and while I understand and appreciate, yes, the council has to pass laws, the executive has to execute, there's no sharing of the space here. The council is mandating something that the mayor must do and do it in 5 days. There's no discretion. That's not shared. That's not a co-equal branch of government saying we would like this to be accomplished. You figure out the most appropriate means to accomplish it within your constitutional duties to preserve the peace. And
at times what you're saying almost suggests as though you think it offends separation of powers for the council to impose non-discretionary duties on the executive, but there got to be hundreds of statutory provisions that tell the mayor you must do X and you must do Y, and some of them are in areas where the mayor has responsibility. Obviously, the council shouldn't be telling the mayor to do things that aren't in the mayor's area of constitutional responsibility. So
there are thousands, of course, agreed. But I think what you have to look at is how serious the implications are on those fundamental duties of the mayor. Again, if riots would ensue in the mayor's mind and belief, why can't the mayor say, I'm not going to produce that in 5 days? It makes more sense for people to cool off a few weeks. Let's have a little bit of an investigation done so we can provide to the public some context and some information rather than scramble. Again, with the prosecution, if the U.S. attorney says that you will jeopardize our prosecution of a terrorist attack, is that something that the mayor really cannot step in and say, all right, I think this is the wrong thing to do? And there's no review to this court on something that serious and that significant. And these aren't fanciful ideas that will never occur in the district. They're real world consequences to fundamental duties. The one comment that council made, and I'd like to highlight it, is how the videos are being released and certain things are being pixelated. There's no authority for the mayor or the MPD to do that whatsoever. None. The statute doesn't say you're permitted to protect the identity of X, Y, and Z by pixelating. Now, the mayor and the MPD have just done that, but anyone could come in, a litigant, submit a FOIA request or challenge that. And there would be no support within the statute that says the mayor was within her rights to do that. Now, do we think that it's a good thing to do? Absolutely. I think council thinks it's a good thing to do. You heard it protects privacy, but there's no authority in the statute to do that. And that's the flaw. There's no discretion. It's produce it, unedited. If there are any other questions, be happy to answer them, but thank you. Thank you for your time. I appreciate it.
Thank you. And I apologize again, Mr. Conti, for trying to steal your rebuttal time. Thank you all again. And we'll take the case under advisement and court is adjourned.
All right. This court is now